close-up, deep action. We created it to give the world 3 times fresher breath and eliminate up to 99% of germs. Maybe we went too far. There's an outbreak of freshness. Now the best ever from close-up. 3 times fresh.
Hello, good morning and welcome to Newsfile. I'm Samson Ladi Ayenini, and apologies, we are about 5 minutes late. But today on the show, first they ignore you, then they ridicule you, then they fight you, and then you win. That's a quotation from Mahatma Gandhi. I love it. Such was the circumstance of Martin Amidu, ABK. In the end, he got praised. In the words of Roman poet Horace, it is sweet and honorable to die for one's country, unquote. But is the Supreme Court being patriotic and in the process injuring the country's business relations with the world? We'll look at that issue and the many ramifications that follow. Isofoton says we won't pay. Sounds like contempt. Do they have any option at the moment? We'll look at that. Will the Supreme petition trial continue on Monday as scheduled? The petitioners have serious issues with the pink sheet count. We will look at that matter as well, and we will deal with other critical central issues that came up in the course of the week. I'm Samson Ladi Ayenini. This is Newsfile, your most authoritative news analysis show. And on this show, we put Ghana first. The show is brought to you by the kindest sponsorship of MTN and Bank of Africa, in association also with Lipton. We'll be right back.
I want to state that some arrests have been made with regards to the fires that we have. We had a conversation with the security involved this morning, and they have confirmed to us that some people have been arrested. And again, the preliminary reports also indicate that yes, some of the arrests, some of the fires may be, if you like, natural, and others were actually as a result of arsenic. And it also confirms the position and the statement His Excellency the President made. I did indicate after the statement that the President, indeed, per the position he has access to information that many of us in this country do not have, and it's important we look at it. A president will not come out and just make a statement without having a proper briefing. And it tells you that His Excellency the President made the statement when he responded to a question that yes, he wouldn't rule out an arsenic in regards to this fire. I think that this preliminary report has vindicated the statement His Excellency the President made in the position that yes, some are as a result of accidents, some by certain phases, and that is why I say that some people have been arrested with regards to the fires, and we're looking forward into arresting. In fact, they have been arrested not only in Accra, some have been arrested even in Kumasi and other parts of the country. In fact, attempts to engage in some, if you like, burn again, fortunately for us, have been foiled by the security agencies.
As far as we are concerned, as a minority, our interest is who did what in this whole exercise, and the law of Ghana must be seen to be applying to those people. Mr. Oyome, we're careful not to prejudice the trial, but in view of the judgment in the Waterville case, the substratum of Mr. Oyome's claim appears to have been removed. That is why we are making the case that to protect Ghana's interest, the money, the amount, which is the subject matter of this suit, should be deposited in court, so that should the case go against him, there will be some money somewhere. If you are not lucky and you win, and the money is dissipated, where are you going to get money? How are you going to reimburse ourselves? But the important thing is that in order to protect the country's assets, we should make sure that the money, whatever he took, is safe somewhere. If he wins his case, he gets it back. If he loses, the money is with the state.
You're welcome back. This is Newsfile on Joy 99.7 FM. And we are also live on a dozen of affiliate stations across the country. You're listening to us live in the Ashanti region in Kumasi on Love 99.5 FM. Now, you're watching us on your Joy News channel on Multi-TV. We're also streaming live at myjoyonline.com and MultiTV World/streams. Now, my guests are seated with Nana Atudazi coming in very shortly, but Abdul Malik Kubaku Jr., Editor-in-Chief of the New Crusading Guide newspaper, is a regular panelist. He's here. Good morning, Abdul Malik, and welcome to the show.
Good morning.
Ni Ayikwe Otu is a lawyer, is a former Attorney General, and welcome to the show once again.
Thank you.
And then Abraham Amaliba. He is a lawyer. He is with the NDC legal team. Good morning, ABN, and welcome to the show. I call him AB, and he just happened on the show also. Yes. All right. Okay, so Nanato Dazi joins us shortly, and then we will be doing the discussion. Your views and comments are invited. 1422. 1422 is a text line. You can also send me a message via newsfile@myjoyonline.com. Now, I'm sure you're aware that Martin Amidu, the entire nation is celebrating with Martin Amidu a second sweet victory. He had in the Supreme Court yesterday, and I have tried to see if I understand the issues as far as that case is concerned and the judgment is concerned. And this was my attempt. There was a loan agreement for 65 million euros from Spain, which was laid before and approved by Parliament in August of 2005 in compliance with Article 181 of the 1992 Constitution. But what has been described as project implementation agreements with Isofoton and the Agric and Energy Ministries, which were signed in September 2005 and 2008 respectively, and which projects the source of funding was to be the money that I already referred to, that is the approved 65 million euro loan. These two separate implementation contracts were not laid before and approved by Parliament. So, the Supreme Court judges agree with Martin Amidu that those two contracts, being international business or economic transactions, required prior separate parliamentary approval. The Supreme Court says that parliamentary approval for example, the 3 billion Chinese loan does not exempt the project implementation contracts that will follow from that same contract from scrutiny by the MPs. And they have also said that since the said two contracts are null and void, the Attorney General erred in accepting the claims made by Isofoton, and the High Court also erred in accepting their settlement as consent judgment, which you know as judgment debt. So Isofoton is to refund that sum, which is in excess of $320,000 and interest on the same from the date of receipt of that money to the date that it will pay. And that was the verdict of the Supreme Court yesterday, giving Martin Amidu 2 wins in 2 weeks. We will be looking at various other matters that have come up, as I told you earlier. The minority in Parliament, or some members of Parliament, have asked for some investigation of certain persons who were involved in the processes of these judgment deaths. They have mentioned, I understand, Betty Moldridrisu, Batin Odro, and some other individuals. We will ask if this is right. Again, we are aware that Parliament has set up an ad hoc committee to start looking into the possibility of promulgating legislation to effectuate Article 181 of the 1992 Constitution. Long overdue. We have heard Wayome, the man at the center of the Waterville, brouhaha, say that he had no contract with government and that he regrets being a citizen or helping governments in these matters. We'll look at the question or the issue of arrest of arsonists who are alleged to have set markets ablaze. And then finally, we will be looking at RLG, the company that is offering boreholes free of charge for MPs. And the election petition and the pink sheets matter is also coming up. We'll look at that one too briefly. Once again, gentlemen, I say welcome to the show. Your messages are welcome. 1422, that is a text line. You can send email to newsfile@myjoyonline.com. I'd like to start with you, Abdul Malik, on the issue of Martin Amidu's second win yesterday in the Supreme Court. What is your appreciation of the issues in respect of which Martin Amidu won this victory yesterday?
Well, I'm sure in the wake of the Waterville ruling, what happened yesterday was quite predictable. If you had followed the trend of thinking that went into the Waterville ruling or judgment by the Supreme Court, it was pretty obvious that what happened yesterday was going to happen. So I wasn't really surprised. And but it comes up with a lot of, implications. From day one, if you had analyzed this Isofoton thing, it was so clear that there was something basically wrong. There are two angles now. The Supreme Court's ruling, both in the Waterville and in this case, brings up a certain substantive matter, the issue of prior parliamentary approval for international business or economic transactions. It's clear that a certain, I think reinforcement of that view is being put forward by the highest court of the land. This is not new. It's been so for quite some time. I mean, if you go through the Hansard, you go to the purchase of the presidential jet, the Gulfstream, there was an argument to that effect. I have the Hansard here, all the parliamentarians across the divide. The issue of 1815 became a subject matter as to how it should be handled. In very recent times, fast forward to the Western Gas, this gas pipeline. This is just 23rd February 2012 Hansard, the Sinopec agreement. If you read this Hansard, parliamentarians debating among themselves. And I've been going through some other documentation where there's a very classic example, the Bank of Ghana. There's this agreement that was payment agreement in favor of Cummins Power Generation. You had a situation where January 13th, 1998, the Deputy Governor of Bank of Ghana, Mr. Yi Osei Kuma, was writing to the Minister of Finance and Attorney General and saying that in view of the provisions of Articles 181 of the 1992 Constitution, particularly 1815, we are constrained to humbly request that you initiate steps to obtain parliamentary approval for the above transactions. Similarly, we should be grateful if parliamentary approval is obtained in respect of the power purchase agreement dated 21st June 1998 in favor of Cummins Power Generation to enable the bank issue the relevant counter guarantee. You know, and then there's a reply from the Ministry of Finance dated 31st July 1998. It says, we have carefully, I'm jumping the first paragraph, we have carefully reviewed this power purchase agreement and the related requirements for payment guarantees. And it is our considered opinion that this agreement, as well as the payment guarantees for power supply services, do not require parliamentary approval. And this is coming from the Director, Legal, Private Sector and Financial Institutions Division of the Ministry of Finance. So you see, we've had this situation across in the last 20-something years, and I'm glad that we have a former Attorney General here who I believe will do a more educated and informed submission on the matter. We've had a situation where even among the people within the system, they have a difficulty as to what must go to Parliament for approval before execution of the contract. Sometimes some of them appreciate that it should go, but they even will ask the contractors to go on site before, hoping that eventually they will send it there. We have this typical example about the gas project. You know, monies have been disbursed. Some monies have been disbursed. They are working. It's of national interest. Everybody knows it's critical to our development. But strictly speaking, that particular contract has not gone to Parliament as we speak. Meaning that the Supreme Court virtually is saying that that whole exercise is unconstitutional. Parliamentarians over the years have debated that grey area.
Let me welcome Nana Tudazi, who's just joined us. Good morning and welcome, sir.
Thank you very much.
Good to have you.
You see, have debated that grey area. And I think this is about the third time we are dealing with this matter here. If you recall, in the last few weeks, what is it that has disabled Parliament to do the appropriate constitutional amendments or modifications, as the language says, relative to Article 1815? It's an issue. And now the Supreme Court in two instances, the Balkan as well as the Atlantic Faroe, have proceeded in a certain direction. And I thought Parliament would have taken a cue from there and perhaps would have cleared that misty area. It hasn't been done. So that ought to be done. But there are hundreds of examples in the past as well as in the present of contracts that have already been executed or are being executed without reference to this 1815. That for me is a significant development relative to the Supreme Court ruling. But you see, having said that, with Isofoton, and that is where the focus is, even in the absence of the parliamentary approval, the previous administration had come to the conclusion that there was something not right about the award of the contracts. First of all, because they thought the ministries that awarded the contract did not qualify to award those contracts under the Spanish protocol. They were not looking at the need for parliamentary approval because I think in their mindset, the major approval, the Spanish protocol, the second protocol that had been approved in Parliament, was sufficient. It's just like some people thought the master facility agreement, the Chinese thing, because the major one had been approved, then it means you can proceed with the subsidiary ones.
On that note, sorry, let me read to you what Justice Dateba, Justice S.K. Dateba, who read the unanimous decision of the court, judgment of the court, what he had to say about that. And, quote, he said, the considerations which Parliament should take into account in approving a project loan agreement will not necessarily be the same as those applicable to what the second defendant, that is Isofoton, calls a project implementation agreement. A very good illustration of the issue under discussion is provided by taking judicial notice of the widespread media reports that the government of Ghana signed in 2012 a $3 billion USD loan agreement with the Chinese Development Bank. It was signed after due approval of it by Parliament. The loan is meant to finance several different projects. Surely, it is unreasonable to infer from the fact of the approval of the loan agreement that Parliament has also approved the details of the range of different project agreements which have not yet been worked out as pertaining to the approval of the loan. A distinction, therefore, clearly needs to be made between the loan agreement and the agreements of the projects to be financed by the loan. This Chinese loan illustration shows that Parliament has a legitimate policy interest in scrutinizing and approving project implementation agreements, even if it had already approved the loan from which they are to be financed. The terms and issues in these kinds of agreements are not identical and therefore deserve separate scrutiny and approval.
Yes, I think that we should be moving in that direction. It makes sense to me, even though I'm told there are some challenges potentially relative to international.
Yeah, we'll look at
the lawyers
aspects.
May be able to deal with that more. But that's, I believe it's tidier to move in that direction. And indeed, in Parliament, in approving the master facility agreement of the 3 billion Chinese thing, also indicated that those subsidiary agreements would have to come to the House for approval. Indeed, it is, that's a consistency. Yeah. Except that in practice, the project, the gas project, is ongoing. Some monies running into millions of dollars have been disbursed without that parliamentary approval. And I'm saying that by effect of the Supreme Court ruling, it means that what is going on is unconstitutional. And then retrospectively, of course, the earlier ones also unconstitutional.
All right.
With the Isofoton, what I'm saying is that whilst the previous administration was not obviously thinking of going for parliamentary approval relative to the implementation ones, they had looked at the protocol itself and indicated that the award was itself not proper because the Ministry of Energy as well as Ministry of Agriculture did not qualify to award under the Spanish protocol. It ought to have been the Ministry of Finance, and some other conditions precedents had not been fulfilled. So on that basis, they did not approve that contract, and which led Isofoton to challenge the issues in court. You know, significantly, this administration, and that's where the muddy aspect is, had a committee, a professional group set up, if you recall. And the professional group, after doing its appropriate research, recommended that there had been no breach of contract between government and the Isofoton. And so, indeed, on that basis, you would have expected the Attorney General's office not to have dealt with Isofoton. But they ignored the advice of their own professional group and proceeded to deal with them. And indeed, it was a disclosure on this very program, incidentally, by my own friend Okujoto Ablakwa, that provoked Martin to proceed to the highest court of the land, if you recall.
We'll be looking at all of that and look at the angle of Okujoto because he's been brought in very forcefully in the discussions after the judgment yesterday. Now, Ebi, tell me, what do you make of this particular decision and now the fingers that are pointing at government's decision to first of all sit with Isofoton and agree on the claims that they had made before government and to pay them in the first place?
Samson, we are talking about two matters here. The one dealing with Waterville and the Isofoton.
We will deal with Waterville. Would add it somewhat when we come to look at the questions, the issues that have come from the Attorney General's reaction, statement, and Martin Amidu's reaction to those statements.
But you want me to
restrict yourself to Isofoton this week? Last week we dealt with Waterville quite comprehensively, but we know that there are fallout from Waterville, and we'll deal with those ones as well. In respect of Isofoton, the court found that the Attorney General's department, or government for that matter, should not have entertained the claims that Isofoton brought before them. And the subsequent consent judgment obtained in the High Court was vitiated by the unconstitutionality of the two agreements.
You see, clearly, you would notice that the Constitution and the Loans Act have been breached on this occasion. And so the Supreme Court was right when, in their ruling, they indicated that Article 181 has been breached, and added to that is the Loans Act. Now, government inherited a difficult situation. These are matters that took place in the previous administration. Now, when government took over, government, and for that matter, the Attorney General, was in a mistaken belief, and they indicated that in their statement of case, was in a mistaken belief that these agreements had parliamentary approval. And so they went ahead and dealt with Isofoton. Yes. Yes.
Parliamentary approval.
Yes.
Check with the clerk of parliament for the records.
No.
Simple.
No.
You
asking...
had mentioned that you intended to deal with Waterville and Isofoton.
Yes.
I want to be sure if you are not confusing two issues, because in the Waterville matter, in respect of the part that concerns Woyemi, the subsequent process that was filed in court,
yes,
the Attorney General says it was under a mistaken belief.
Yes. I
am thinking that's what you may be referring to and incorporating into Isofoton.
Yes, so that was in Waterville. So that portion of it was in Waterville.
All right. We're speaking to Isofoton.
Isofoton, right? Well, for me, if we are talking about the Isofoton and you want me to limit myself to the Isofoton, I would say clearly that the ruling of the Supreme Court, for me, was in the right direction. Because if government dealt with Isofoton and did not avert its mind to the fact that the Constitution has been breached, and did not also avert its mind to the fact that the Loans Act has also been breached, I think that the Supreme Court was right in that. But Isofoton also made some demands. For instance, they claim that they did some work, and for that matter, you would expect that they are paid those monies that they did the work for. I think that what the Isofoton case tells us is that there is the need for Parliament to, as it were, restructure and put in place modalities that would ensure that these international agreements, business agreements, or economic transactions, which are of international nature, go through the parliamentary procedures. And as a matter of fact, there's even some confusion as to whether, when the Constitution said that the Parliament would have to put in place mechanisms and modify them in such a way as to take on board international agreement, does it need to go through the same formality, or there must be a special way of looking at these type of international agreements? I am happy that Parliament just last week took this matter seriously and have indicated that they are going to restructure their loans agreement portfolio, how to go about it.
The Isofoton matter in the role of government or the Aegis Department, there is now reference to the famous, Sunshine Crusade that Okudzeto spoke about. And subsequently, Martin Amidu came forward to say that even Okudzeto has sought to compromise him, because he called him, pleaded with him to, grant Isofoton what they were requesting. Now, people are pointing fingers and saying that it appears that certainly Martin Amidu has reason to believe that some fraud was going on.
That is the word of Martin Amidu as against Okudzeto's word. Indeed, I have heard Okudzeto indicate that his ministry, then at the Ministry of Information, is a place where they receive all manner of information. And so when these people come with that type of information, they, as a ministry, will want to make enquiries from the appropriate ministry and to find out the status of those matters. And so the call he placed to Martin Amidu was a call meant to clarify the issue, and that he was quite aware that this matter was in court and would not have, as it were, suggest to Martin Amidu to bend backwards and accept the claim made by Isofoton. And so now we have Martin Amidu's claim as against that of Okudzeto. I am not in a position to believe any of the two. But again, it shows that what took place, that is in the Isofoton issue, was a mess. And I am happy to indicate that the Attorney General in this Isofoton matter sided with Martin Amidu and trying to, as it were, mop up the mess.
You mentioned sided with Martin Amidu. This is the second time. It's already brought you a lot of trouble.
No.
Okay.
I didn't say supported Martin Amidu.
Okay.
Sided with Martin Amidu.
How do you prove that you sided with him? Because we know from start that he's been vilified.
No, I'm talking about the Attorney General's conduct in this matter. You can see that from the processes filed in court. And if the processes filed in court do not traverse what Martin Amidu said, but if the processes indicate that they agree with the claims made by Martin Amidu, you can only but come to one conclusion, that the Attorney General in this matter, led by Marita Briopong, sided with, and the choice of where I'm careful in the use of my
How
word.
do you prove that? For example, I can see that what you have before you is a statement of case of the Attorney General, who is the first defendant in this matter. How do you prove that? Give us a line or two, any statement in here that shows unambiguously, clearly, that you sided with Martin Amidu in this matter.
You are asking me to go through this, and that will take some time.
If there is, you can just hold on.
Yes.
I'll move on.
Yes.
You look for specific portions
example.
of that sided with Martin Amidu, and let's share with the rest of the world. Now, Mr. Ikotu, the defendants, particularly the second defendant in this matter, and it's instructive to note that the court struck out the third defendant as not a necessary party, which is Anani Eje Forcing. The court struck him out that he was not necessary. He was an agent acting for the principal, Isofoton, and in law, because his acts were for and on behalf of the principal, it is the principal that takes the liability. So when we speak about this matter, he is not to be seen as a defendant. So the second defendant, who is Isofoton, was urging upon the court that to seek to have subsequent approvals by Parliament after the parents' agreement, which is the loan itself, 65 million euro loan, had been approved, is to seek to, and I want to quote them, they say that is to seek to impose a needlessly burdensome duty of sheer formality on Parliament that is clearly bound to increase and extend Parliament's business to gargantuan proportions. That this is needless. You don't have to do it.
Well, I don't agree with the point of view at all. I think we have one constitution and one constitution only. We are all bound by this constitution. Until there's an amendment of a particular provision of the constitution, I think the constitution is supreme. All other laws should give way to the constitution where they are inconsistent, and all human actions should be measured in terms of the constitution. In fact, I'd like to take us back to the preamble. The spirit of the constitution, we say that in the spirit of friendship and peace with all peoples of the world, and in solemn declaration and affirmation of our commitment to freedom, justice, probity, and accountability. Are we interested in probity and accountability? If we allow that to be our guiding post, then we will not be found and caught in this web of fraud and inaction and conspiracies and somebody trying to reap where they have not sown. You see, 1815 is clear that this article shall, with the necessary modifications by Parliament, approve to an international business or economic transaction to which the government is a party as it applies to a loan. So why? If you think what you are going to do is an international business economic transaction, they're asking you go to court. Because 181 applies, this article applies to any other international business or economic transaction. Now, why do we go to court for the court to give an interpretation? It is to guide our, future steps. So Faro International, whatever, has been in the law reports for some time now. And they've made the point clear that without it, that agreement is null and void. All they have done is to reiterate it, that please do that. Again, you see, the difficulty with this NDC approach is that something had happened in an MPP era. I believe there would have been records. Even if there are no records, the people are still alive. Call them, contact them, find out what has happened. And a contract has been abrogated. Then you come and say, oh, we don't think that that abrogation was proper. So as for us, we're going to accept, to sit down with them. If they knew they had a case, why didn't they sue the government that abrogated the contract? Why didn't they deal with them? But they waited for the government to exit. When the government left, then they found a new government in place. Then they go to them, and they become more sympathetic.
To be fair to them,
yes.
They did go to court when the NPP administration was in office, and indeed obtained a default judgment.
The judgment. Oh,
yeah.
Okay.
It
position,
was during the NDC administration that they now went and got the consent judgment.
You see? But my worry is this. When my friend on my left said that somebody was misled and that they were under a mistaken belief of parliamentary approval having been given and all that, that's why we always say that if you are there, you should have your eye on the ball as the Attorney General. You direct affairs there. So you've got to convince yourself that the people have a case before you decide to
But I was asking you about the larger issue and implications of this strict compliance with this particular provision, where the defendant was urging on the court that for as long as you have approved the parents' agreement, and you are talking about accountability,
I have not left
is the
that
government
at all.
not going to account after it spends what you have approved? Will they not account? Will the Auditor General not audit all of these spending?
No, I'm saying that if we are guided by probity and accountability, then before we take a step, we want to be sure that everything is transparent. So if there is the need for an parliamentary approval, please do that. It is only when we leave these guiding posts that we run into difficulty. And then the rush, at the Agency Department for Settlements, I have been there before and I know that sometimes they bring civil claims. And instead of putting up a fight, they just decide, why don't we, try and put our heads together and say if we can meet this, claim and then we settle it out of court. That culture ought to change. That when you get a brief and you are not even sure of your defenses, there are other people you can consult who are even outside the Agency Department. So when you are not sure, consult. That would assist you to get to the bottom of the matter. But I have said it elsewhere, that I found myself literally entering appearance. Because the writ comes, nobody enters appearance. You know where we will arrive at. As a lawyer, you know what we call default judgment. Yeah. So this is what accounts for the many default judgments that you find against the Agency Department, because we failed to enter simple appearance. In my period, I entered all appearances personally to ensure that you cannot go and take a default judgment, at least for failing to enter an appearance. When you go to the next step of defense, then we will be served. You can't go and take default of defense without serving the other side. So at least we'll be served, and then we'll put our best foot forward. There are a few things there which have not been done properly. I got there to find out they did not even have shelves on which they neatly arrange their files. So that when something is served, you can put it on. And then some of these things get mixed up. Right. And before you say, Jack, default judgments have been taken. It is the government that is suffering. The Supreme Court has come down again. I don't think it said anything different from what it has been saying all along. No. So I do not believe that the Parliament may have to even go back. Let us accept that international business or economic transactions are subject to parliamentary approval.
All right.
And let's
Now-
move
now
from
to
there.
that.
Let me get you the paragraph.
All right.
And you are talking about paragraph 25
Of your statement of case.
of the Attorney General's statement of case. It says that the first defendant, and the first defendant is the AG,
That is so.
agrees with the plaintiff, and the plaintiff is Martin
Martin
Amidu,
Amidu.
that by virtue of Article 1815, the agreement with the second defendant required parliamentary approval, which, not having been given, rendered the two agreements null and void and of no effect, and therefore praised the Honorable Court to order the refund of any monies paid to the second and third defendant forthwith. And they cited the Federal Atlantic
All
case,
right.
and they cited Vulcan Energy case.
Okay.
So this is a testimony that the Attorney General sided with Martin Amidu.
But all this was avoidable if the Attorney General, and here we are not looking at the personalities, I'm looking at the office, had also gone by the advice provided by the professional group that indeed there had been no breach of contract because those contracts did not become effective based on certain non-fulfillment of certain
All of this would have
conditions.
been avoided.
All this would have been avoided.
Okay. Nana, I want you to, take us on, move from to a different path, perhaps, to answer the question. Isofoton is a foreign registered company. It comes to Ghana to want to do business with you. It is your job to take the processes to Parliament to have them approved. You fail, you neglect, you refuse to do your part of the bargain. In the end, he does some part of the work for which he's used money to do. And you come back to say, because I failed, refused, neglected to do my part of the job, refund the money. Will this not be injurious to Ghana's, international business relations? That's the other question that's coming up.
Thank you very much. I think you couldn't have put the question right, But before I start, I think, again, let me say congratulations to my friend and colleague, Martin Amidu. It's always a pleasure to, whether you want to say it in public or not, to win a case, to draft a writ, prepare a statement of claim, go through the processes, argue your case, and you get a judgment, you feel satisfied that you've arrived as a lawyer. So, two cases, yes. I wouldn't take the shine of Martin at all. And I think that the fact that he soldiered on, went alone, filed his own writ, paid his own bills. I mean, really, I think that he's gone the extra mile as a public officer. But as I said last week, I'm simply not surprised. That's Martin Amidu.
He equated his act to someone dying for his country.
Yeah, I'm saying that. I'm saying that don't
patria.
No. I'm saying that's why I'm saying I wouldn't take one bit away from Martin. He deserves it all. But I'm just saying that there are many more Martin Amidus also. And no, please, I'm saying.
Nobody condemned you for initiating the action.
Oh, please, just give me a chance. I said that there are many more Martin Amidus, and what I'm asking is for this country to try and identify the many other Martin Amidus who on a daily basis are performing. It's because there's a public big case that you see. But just to answer, before I go to Kweku, I think that Kweku's opening was fantastic. I don't know why he took a very neutral line. Maybe that's his style anyway, normal, of talking about the broad picture, the broader picture. And I think that I share almost everything that he said about the nature of this matter, even though he didn't put it in a formal legal sense. You see, these two cases, Waterville and Isofoton, they represent the confusion in our legal, thinking, minds of judges, of lawyers over a certain period. I want to put it this way. The unsettled nature of the legal system. What is the law? What does the Constitution say about this? It's what has created all these problems. Unfortunately, the Supreme Court has come out and has done a great job over the last 3-4 judgments in settling, what do you call it, Ferro-Atlantic. You talk about Balkan. You talk about Waterville. You now talk about, Isofoton. The law is clear for everybody, both practitioners, the professionals, in the field. Nobody, anytime you move a document to any other office from now in government, it will be absolutely clear. Do you have a parliamentary approval? It will be there. It's now clear. And that is a function of the court. You see, it is the function of the court to say what the law is in fact. I'm sure that's what we learned at the first year law school, That's what we tell you. So when the legislature will prepare the law, you see, it will spawn it out, to put it out. So one man will read it, you have one interpretation. Other person will read it, you have another interpretation.
You said this situation represents the confusion in the minds of the judges about what the law is in respect of this issue.
I think the judiciary.
I think, and I want to suggest to you that this rather does expose the official, and I borrow from Abdul Malik Ukubako, official ineptitude in following the law. Because the argument is that the law is clear. Take it to Parliament and get approval. You don't take it there.
No, sir. Let me put the point here. I'm saying that I don't want Martin's victory to be, set aside at all. I think what Martin has succeeded in doing, he's gotten that the portion of the Constitution absolutely clarified, for avoidance of doubt. I don't think that for a moment that Martin has ever had any doubt about in his own mind that all those processes needed to have parliamentary approval over the years. But that is his view. I'm just saying that there are other persons, including judges, who firmly believe that some of these, sets don't need to go to Parliament. So why did some of the High Court judges give judgment in spite of it? You understand? Why did some attorney generals, or for that matter, let me mention to you that contrary to what my colleague, a former attorney general, is saying, both NPP and NDC attorney generals in the past have held a certain position, most of them, that you don't need to go to Parliament for this or for that. We have, apart from Waterville, which occurred in that period, you ask yourself, did Waterville ever get parliamentary approval? You get me? You did Shanghai, which was giving the contract, in the NPP time, the work taken from them and gave it. They didn't go to Parliament. They didn't get parliamentary approval. Shanghai must have been paid. We have Balkan energy case. That was also during their time. What happened? Why I am interested in the question you raised is because I was solicitor for a bank in the Balkan case, given an amicus curiae status at the time, and I'll come to that in a moment. The judges, the Supreme Court, almost the same court, had with Dr. Bar presiding. They sympathize with the situation, but they say, alas, this is the situation, the constitutional provision, and we must all abide by it. So they throw the line. There's a case involving Cape Coast Sports Stadium. It was at the commercial court, also during the NPP period. Now that case is being in the court, in the commercial court now, where an award was made without going to Parliament. You get me? The people did some work. At the end of the day, government, the Attorney General and government comes and says, "Oh, sorry, we don't have parliamentary approval. So, your contract is void. And illegal. Federal Atlantic, it's all that. What I'm saying is that we run the danger of, destabilizing our own international business reputation unless we settle things. And that is why the judgment, this particular Isofoton judgment, is good for everybody. It settles everybody in the minds of the investor. He knows what. The investors come, they rely on local lawyers. Do I need to do this? I say you don't need it. You go to the Attorney General. Attorney General says you don't need it. In a classic case, I believe, of Balkan, the Attorney General wrote a ruling to say that you don't need parliamentary approval. A subsequent Attorney General, I believe, Martin, raised a matter in Supreme Court. You need, parliamentary approval. So, on the basis of the earlier, you don't need a parliamentary approval, work started. On the basis of, we don't need parliamentary approval, you need parliamentary approval, the contract is void. Unfortunately, in Ghana, when they say, well, it is void because it doesn't comply with the Constitution, and therefore it's illegal, people have a certain concept of illegality. The thing is corrupt. The thing is, so there must be some money changing hands and all that. You see, I want to round up. So there's a danger. I'm saying that you must understand that a case is or a contract is void because it hasn't complied with certain legal regime. It doesn't mean that it is an illegal thing. So for me, I would say that yes, Martin has helped us to solidify and settle the case. But just in concluding, I said, let's not forget, I had one Honorable Kofi Owusu-Yeboah. He was solicitor for Isofoton. This gentleman used to be the MPP Volta Regional Minister. On July 23rd, 2012, he was attacking Honorable, Kojo Mpianim, the Chief of Staff, that he said that the Isofoton didn't have an agreement, a valid agreement. What had happened was that Kandapa had made an award. Professor Okwe, the new minister or so, had said, it didn't comply with the new PPP, Public Procurement Act, so he took it away. But before we could say Jack, and then advertise the whole Isofoton thing, advertise it. Before we could say Jack, a letter from the Chief of Staff in PNM comes to say, no, take this particular one and make the award. So that the first company that I wanted said, if we didn't go through the procurement processes and you've advertised, why don't we all, have a common, come from a common playing field situation? That is what was the problem. So when the new company, handpicked, without going to Parliament or whatever, was awarded that, then Ajay Anani or whatever his name, they went to court and they obtained judgment. Okay. You get me? Right. So I'm just saying that. I'm just saying that we must understand that we are not talking about necessarily talking about criminality.
Thank you.
We are talking about constitutional issues.
Now I want us now to move on to that aspect of Anani Ajay saying that they won't pay. Literally saying they won't pay, and that I've heard also elsewhere that he's thinking that probably they could even go for a review of the decision. This one was a unanimous one. I don't know who is advising him in that direction. Yeah,
but I thought the more responsible thing to say was to say that we will seek review, even if the odds are against you. But to say, it's amazing. I mean, it is not an educated and a responsible statement to say when the Supreme Court makes certain orders. The more responsible thing is that, well, we disagree, and he said so, and we will proceed to have a review of the decision. But to go out there and say, it made me remember a champion for a moment. I don't see how sustainable it is. That's the advice I'll give to him. It was clear from day one that they didn't have a case. Martin moved in the direction he moved because everything was pointing to a situation where government was getting ready to effect payment. In spite of the fact that there was an appeal pending against the High Court ruling at the Court of Appeal. Okay, processes had been initiated, and everything was looking well till the Deputy Minister of Information disclosed that, well, we have no case and we are proceeding. And you see, look, there's one significant thing why these things do happen. There was a letter which we read here that an officer of the Ministry of Agriculture, in terms of his advice, was to the effect that, look, yes, and I'll quote, the person was Mr. Seth Mensah Dumoga, Deputy Director of Finance and Administration. He signed this letter on behalf of Mr. Kwesi Ahoy as the minister, substantive minister. And he said, relative to the professional group's report, he said, such as the date of contract and its non-compliance with the procurement law, etc., would have been the basis for a defense against the suit. But in his view, because it was too late, according to in his opinion, what he said was that the way forward may be to identify those responsible for the abrogation of the contract and charge them with willfully causing financial loss to the state. You see, so there's a mindset. There's always that political contest that, look, our predecessors didn't do the right thing. They are the cause of the liability. So let's effect payment and proceed to punish those we perceive as being perpetrators of the liability. This particular mindset has informed a lot of the payment judgments that we've made. It's the politicization, right, in the mindset of those who are in charge of a system. So they fail to do due diligence. They fail to call even the previous administrators to interact with them in order to get the records. I'm telling you, it's a basic thing. I'm not attacking any party. This can reoccur, even in a situation of a change of government. When you come with that mentality that, look, all I'm out to do is to look for who caused the liability, and I'm not bothered about the beneficiaries, so let me proceed. When there's enough documentation that would have made you realize that, look, there wasn't really a liability, and that indeed there was rather fraud that had been used to procure the payment. No, let me finish. You may misunderstand me. See, with the Waterville thing, the court indicates fraud. Create, loot, and share. It's nothing but fraud.
But I told you.
No, please, let me finish. You are misunderstanding me. You are misunderstanding me. I am saying that relative to that part of create, loot, and share, the court is telling us that there was collusion. There was a conspiracy. That's what the court is saying.
No. It has actually said that if the attorneys had scrutinized the documents available to them sufficiently, they would have seen that there was no basis.
Exactly, that's exactly what I'm saying. I have not done any politics here.
What you are saying is perfectly right.
Yes, thank you.
Yes, it's perfectly right. Except that you are not looking at the position from the pure legal thing. I'm saying this, what you are quoting, just as you said, it's obiter. It's a statement that came from Mr. Justice.
No, but even in the substantive...
Please, but let me just go on to a little point I said I wanted to mention. You know, Kweku talks about the political, mindset and all that. That's true. In a certain sense, I was a victim where I didn't think that I'd done anything, but I took trial.
That's right.
Part
I
of
agree.
At what do you call this Miss Cotton? What's the name?
You were discharged and acquitted.
Thing. You get me? Of course, if you do it, there's the likelihood that somebody will also get it. But in the case of Isofoton, government was obliged to take steps to pay at the time Martin moved in. Martin knew it, but it was at the time when the accounts of Ministry of Agriculture had been garnished. Their international account had been attached. Something real was happening. The money didn't exist. You get me? What do? Do you say that I will go to court and go and set aside, go do a 3-year process before you have to, make choices, And at the point in time, I know it because I studied a bit of it, where the option was that, okay, let us find a way of settling this matter. Because work has been done.
All these orders, garnishing and everything, have been pronounced as illegality in the first place.
No. It is. But I thought that the question you put to me will still come, and we haven't answered it. And that is, what will be the effect of all this on our own international stature?
Thank you.
We can be a rogue country.
As Martin eventually did. If Martin had followed the advice that the Solicitor General and I think the other officers had given him, he would have gone ahead and effected the payment. It was when they brought to his notice the professional group's document. He read it and called the attention to the contradiction.
All right, thank you. Thank you.
Ms.
Aikotu, I want us to fast forward again and look at, this is a foreign registered company. How are we going to get this 20,000 or so dollars? How are we going to get it from them? How can we enforce or execute the judgment?
Well, before we come to that, let me say that both speakers have not primarily differed from what I have said, that let us be guided by accountability, transparency, probity. Once we use that as our guiding post, I'm sure we'll get out of some of these pitfalls, you know, and that you as the Attorney General have a responsibility to read whatever is brought before you. Do not just, accept advice from all kinds of corners, because the buck will stop with you. Now, it comes to execution. Are we saying that they don't have anything here to begin with?
On the face of the suits or the rates, it's supposed to be a foreign registered company. The address is house number 3. Is it opposite Shaba Warehouse, Parakou Estates, Domi Accra? That's the attorney who was having the power of attorney, but the company itself is in 928014 Madrid, Spain.
Yeah, if we have an agreement with them in terms of enforcement of judgments, then that is with the country, between the two countries, then this judgment will have to be taken there to be registered. Once it is registered, then it can be executed in that country.
All right. What do you say to what he's saying now, the attorney for Isofoton, that they are not inclined to pay?
Well, that is sheer contempt of court. I mean, you don't do that with the highest court of the land. Let me explain that under the new High Court rules, we no longer have what we call judgment prisoners, judgment debtor prisoners. In other words, the fact that you cannot pay your debt does not mean that you should be sent to prison. That has been taken out of the execution processes under CI 47. Well, if we look for the money and we are unable to find it, or we cannot use any of the execution processes, garnishee, sequestration, FIFE, whatever, and then we're trying to move against you to punish you, then you can say, well, I cannot be put to prison for just having incurred the debt.
All right.
But to just bold-faced tell a Supreme Court, I'm not going to pay, that amounts to showing contempt of court. And I believe that in those circumstances, when you are cited for contempt, the Supreme Court may want to deal with you.
So he should be careful.
He should be careful. If he's the same person who was struck out,
yes,
then it's even proper for him. I mean, the Supreme Court feels that this is a corporate matter and that the company is there. The company is a legal entity. We can deal with that company. So leave out this individual unless you're able to show that, as was decided in the Moko case, to join a managing director of a company is to show that the managing director himself has done something. Otherwise, if you have a problem with the company, just go to the company. So he's been left out. It should then be measured in a way.
What will be the options available to attempt to stay the execution of this judgment?
You can only stay execution, first of all, if you file an appeal against the decision. This is a Supreme Court case, so you can't file an appeal. You can only file a review. So perhaps while the review is pending, you can take it that, well, something is yet to be done. So please, can you stay execution while my review application is pending? Beyond that, I cannot foresee what else they can do. But then when you have a 9-0 kind of situation and you are going for review, you must be extra careful. Are you going to tell me that if they add 2 people and now the number becomes 11, the rest, all the 9 who voted, I think about 7 of them will go, or 5 of them will go the other way. I mean, it's not
the path of the law. I mean,
yes.
And you know that it is possible for all the judges to change their mind. If in exceptional cases,
yes.
when some matter
Now
is brought up,
you have used the word. You have used the word. You think it's
I'm saying there is an
another
absolute terms in
opportunity.
which you put the case.
No, it
That's
is
another
absolute
problem.
because it never happens. We've been in this country.
Oh, but there's a
You have
provision.
9-0, and you are telling me you can find something exceptional. For 5 when 2 are added.
If, for
now
instance,
to
as far as
change
you
it
are concerned, this is waste of time.
It is just not possible. It would not happen.
I think that, sir. I think that basically your question is even premature. Your question, the way forward in terms of execution is premature.
No, you're asking for stay.
Yeah, I'm saying that the whole issue of execution is premature.
Why?
You get me?
Why?
It is due, you can go ahead. But these are the legal processes. I think that our business is to educate our listeners and our viewers as to the possible way out in all this. Yes, government can immediately get up and go ahead, try and, execute the process. The people, and I thought I heard you say it, that the people had done some job. In all these situations, work had been done. Now, in international law, and we are not a rogue country, in international law, there's a recognition for work done. Within our laws, both substantive, equity, and whatnot. If a person does a job for you, and in the course of implementation or after implementation, it's found that there was some kind of illegality or some reason for it to be void, it doesn't mean that the work that you've done, you ought not to be paid for it.
This ruling negates any rights that arise from.
I'm coming. So I'm saying, well, there are so many legal, so I'm saying that let us give ourselves a little time. When in law, as my understanding of it, I may be wrong, but when you have such a situation and then the axe falls, we say the axe, it falls where it falls. So all the parties will have to be restituted. Why? I'm saying that you have brought, for instance,
you're saying that it's not barefaced, contemptuous
Absolutely.
When the man says we won't pay.
No, for him, I think that it was wrong choice of word. Yeah. But incidentally, I see here right in front of me, and that's why I'm amazed. Saturday, 22nd June. When is it? That's today. This is Ghana Web. I don't think Mr. has seen it. What does it say?
Yeah, that Isofoton should negotiate if indeed government owes them.
This is what I'm reading. And
it's attributed to Aiko too.
You see, now,
is it not the case? Is it not the case that the order of the Supreme Court now has to be enforced before any other thing?
I'm just saying that I share the sentiments which he has there, but it shouldn't be only to the party. Government must also learn to negotiate. I say that Martin's victory, which I share, is that he's clarified the position for all erring, officials, legal or otherwise, that next time must go. Okay. But what about work done? You say we are not going to pay.
You see,
okay.
Some of these
gentlemen, kindly hold on with your reactions. I need mandatorily. I have to take a break at this point. To return, don't forget your points. We'll have to share them with the rest of the world. This is Newsfile, brought to you by MTN Everywhere You Go and Bank of Africa, and also in association with Lipton. We'll be right back after this break. You're welcome back, and you are watching us on your Joy News channel on Multi TV, and you're listening on Joy 99.7 FM and over a dozen affiliate stations across the country. I'll get to you, gentlemen, to get back to the issue briefly, but let me speak to the Honorable Kojo Mpieni, former Chief of Staff. His name has been mentioned in respect of the Isofoton matter, and he wants to clear some small matter. Good morning and welcome to the show, sir.
Good morning. Thank you for allowing me to come in.
All right. So what's this point that you want to intervene?
I think Mr. Atugaze, in explaining why the two ministries cancelled the so-called agreement, said that with regards to Ministry of Energy, President Okwe said, no, it's cancelled, it should go on tender. But with the Ministry of Grid, from nowhere, I sent a letter saying that the work should be given to another company, and that was the problem. I don't think that's what happened. And I believe he was in my position before I came, so he knows how the government system works. I can't just sit there and write a letter to another ministry and saying, take this instead of that. You know, the whole, and the amount involved, actually, I want to correct, was 60 million euros. The 60 million euros. What happened was that the president constituted a committee, which I, as the chief of staff, was the chairman. And so this committee decided to get help from the Spanish authorities as to which companies are likely to do the work and do the work very well. So we contacted the authorities in Spain through our embassy. I believe the ambassador then, Mr. Chegao, so is here, so anybody can ask him. And they recommended a list of companies to us. So as the committee decided that we should give this to that company who has been recommended to us. This was sent to the president, and the president approved. And me, being the chairman, wrote to the Minister of Agri that this project should be given to this company. So that was a decision of government, which I, as the chief of staff, communicated to the ministry concerned. So this wrong impression, which goes on and on, that I abrogated a contract and I, on my own, selected a company and gave the job to, is wrong. It's not true. He knows. He's been there before. He knows that anybody, minister, chief of staff, cannot abrogate a contract entered into by a government. If you do that, the president will sack you.
I see.
Yeah, well,
all right. Thank you. Thank you very much, Mr. Kojo for this clarity.
Thank you.
All right.
I think I have
no. I'm going to come to you.
I think Mr. Mpeni deserves an apology.
All right.
For him, I'd say that Mr. Mpeni, clearly my colleague, he's subsequent to my vacating the office. I happen to be the senior prefect for the chief of staff's living. He knows it.
All right.
But we take we are the guy, fall guys, you understand?
Okay.
We write the letter, and but the fact still remains that letter exists. Indeed, in a letter, what do you call it? Dr. Mr. Jogati asked that the Isofoton matter should be investigated, and in it, he said that the letter was written by Mr. Mpeni. Understand it. A chief of staff wouldn't on his own be the one inside the government. But the fact still remains that a letter was written to sidestep the procurement process.
Okay.
That is all.
You have apologized to him that you presented the matter as
I'm sure
he did it in his personal capacity,
what I'm saying.
Somewhat. Well,
I'm sorry if you think.
I'm told that Mr. Mpeni likes my shirt. Well, just call Latida. It is 026-5650-918 or 0204-336-444. So all of you who are in love with my outfit, just call Latida, and you won't believe the price. It's very, very cheap.
Now let me react quickly to this Ghana web story. I think those of us who do frequent commentaries are now having to deal with some of these problems. You have not spoken with a particular, station. They monitor you talking somewhere, and then they pick what they like and go and put it and make it even a headline. I was talking to City FM, and they were asking specific questions. And so you will find in the web that what I said was
Ghana web that wrote the story. You can see they have shown where they got the story from.
Yes, but if they they've curbed it, the thing is based on hypothesis, if they believe. Because they were saying that they're not going to pay because they think government still owes them.
Right.
And I said, there is something in law we call compromising a judgment. So if they believe that they have a case, then they are talking about negotiation.
In that case, the headline is not wrong. The headline is still using the conditional clause.
If there's nothing, I mean, if you read it well, what is there? To me, that's not represented. I think it is a matter of negotiation if they believe that they are still business partners with government.
Read the headline.
So how do you go back and I thought, if indeed government owes them?
Yes.
If indeed government owes
them,
no, not necessarily. They should negotiate. It's possible to negotiate, to say whatever you want to say, because it is your case that government still owes you. So go and see government talk. But you don't go stand there and tell the world, I am not going to abide by any judgment.
I was at the point of taking your comments briefly on what is being said to be the likely implications of this, kind of judgment, which says because you didn't have parliamentary approval, it's void, and so you will not be paid any money.
I believe I was in court when this issue of quantum merit was raised by one of the lawyers. And I think it was shut down that if the thing is null and void, it is null and void.
Finished.
I was there. And I think if we go by the Faro Atlantic and all that, nobody has benefited. The difficulty is that sometimes the Supreme Court itself changes its mind on some matters. And so with the country, town and country waste thing, that is where you have this difficulty. You say, well, the contract is null and void, but the people have done some work, so why don't we look at quantum merit? It may not be the consistent position, but maybe that was a special case in which they believe that some quantum merit thing ought to be done.
That about distinguishing that in the Waterville matter.
Exactly. So we do not have to create the impression out there that once work is done, work has been done. No. When I was at Trinity, I do recall that these international people will come to you, first go to the Minister of Finance to find out the contract's viability, the competencies, whether they are in line with the law, and then they will also bring it back to the Attorney General's Department for what we call legal opinion on the matter before the thing goes. So they know what to do.
There's been calls for sanctions for some people who have been involved. And I'm not talking about only the Isofoton. I want us now to move beyond Isofoton to last week's judgment as well. That some people who were involved should, in the process, in the entire process, should also be investigated. I'm sure you have heard the minority leader, you have heard other people to suggest the same. And Jose Usu, who is also responsible for is the chairman of the Constitutional Legal Affairs Committee of Parliament. He's also endorsed that position. What do you say about that?
I have always maintained that judgment just don't come from the sky and just fall on us. I have always maintained that it's the actions and inactions or missions of public officers. And so one way to look at it is to hold these public officers accountable. So I have always maintained that position. Now the call to hold them accountable is in the right direction. But I'm hearing a cutoff point, as if to say that we should not go beyond the period that we are looking at now. That there were some public officials who caused these problems that we have inherited. That in 2006, when these matters came up, some people, some public officials might have done things that were not in conformity with the laws. So I agree that those who made the wrong payments should be held accountable. Those who also caused the judgment debt to come about should also be held accountable. And when you look at it, most of these contracts came from the previous administration. There were some actors there. Let's hold them accountable. Let's hold also...
What accountability are we talking about here? So, for example, is it the case that if there's a liability that is being fixed on government in respect of the monies and which government may have to pay, these individuals should be made to pay those monies?
No.
What is the accountability?
You are calling for people to be held accountable. Are you using the criminal justice system? Is that what you are using?
Because financial loss?
There are a whole lot of laws that can be used. Is that what you are calling for? If that is what you are calling for, look, the sword must cut in both ways. And so I'm saying that let's go beyond just the current officials who we all see now having acted in one way or the other that has caused what we are seeing. But there is a remote cause. And so let's take on board the remote cause, add to the immediate cause, and ensure that the whip is cracked in such a way that we find that everybody who is found in that chain is held accountable.
If you may also respond to the criticism that have come against government, especially the Deputy Attorney General, the Attorney General's Department, about your alleged support for Martin Amidu in this process. Martin Amidu has come out 2 times to say that you're wrong. He didn't get any support from you.
I think it's a choice of words. If the statement is that they supported Martin Amidu, one will be thinking, did Attorney General pay the legal fees or the filing fees? Did the Attorney General help to draft the processes? But that is not how it looks. What it looks and what it is that from all the pleadings, you notice that in this matter, the Attorney General has been cited as a defendant. So one would have expected the Attorney General will go to court and defend its position as a defendant and resist any attempt to be held accountable by Martin Amidu. But you have an Attorney General who is in court and virtually abandoning her position regarding some actions that led Martin Amidu to court and saying that I side with Martin Amidu. So for me,
once again, you are using the phrase "I side with Martin Amidu."
Yes.
And so far, you have not given us any evidence to show. It is only in the case of the Isofoton. Yes, that's clear. You supported that.
Yes.
In the case of Waterville, what is it that you did in your statement of case, which you have been told by the Deputy Attorney General, is what you mean when you say you supported him?
Let's go to...
Or you sided with
his
position.
I have the Attorney General's statement of case here on Waterville. Let's go to paragraph 60. Paragraph 60. Or you want...
You're still watching us on your Joy News channel on Multi TV. You're listening to Joy 99.7 FM. I've got your messages here. So here. You are there?
Yes.
Okay, show us how you did
Paragraph 46. It says that, my lords, as rightly described in paragraph 3 of the plaintiff's statement of case, so this is a statement supporting, and it goes on to say, the second defendant, and this is Attorney General speaking, is a foreign registered and resident company which purported to enter into 2 similar but different contracts with the Republic of Ghana, both dated 26 April 2006, for the construction, among others, of stadia in Ghana that were not approved by Parliament. These contracts qualify for characterization as international business transaction under Article 1815 and could only become operative and binding on the government of Ghana after being laid before Parliament. And this paragraph clearly supports paragraph 3 of Martin Amidu's statement of case. So what else? Because the Attorney General is not going to take Martin Amidu's statement of case and write for him.
So what was this conclusion?
Conclusion of who?
Or whatever I was writing.
Because it is interesting. You have referred to a statement that seeks or purports to support Martin Amidu. But how did you conclude? In the last one, you read the conclusion to us.
Yes, if you want the conclusion.
Yes, the conclusion that will tell us whether...
My lords, in conclusion, my lords, the government of Ghana purportedly entered into 2 contracts with the second defendant dated 26 April 26 for the rehabilitation of stadia projects in Ghana. These contracts qualify for characterization as international business transactions. The said contracts could only become operative and binding on the parties after being laid before Parliament. In the case herein, and that's the conclusion, the contracts have not received approval by Parliament, could not be operative. None of the parties to the said contracts could have relied on the provisions thereunder. Therefore, the purported mediation on Clause 161 of the said contract was null and void, and payments made on the basis of the award by the mediator were unconstitutional and same should be refunded.
So
right.
You
get a point.
Finish the whole thing.
Okay. You see, I want you to finish the whole thing because there's a last paragraph.
There's a last paragraph.
Read the last paragraph. What does it say?
60. My lord, it is submitted that the first defendant mistakenly made payments to the second defendant and the fourth defendant, and that the said payments were fraudulently procured. This is an attorney general who has man up.
It reminds me of what Kwekut said a while ago that Nana Tudazi did not agree with him. It appears that even you, the defendants, it's not only the judges who said so, but even you, the defendants, in your statement of case, said the monies were procured by fraud.
Yeah, by the second, the third and fourth.
No. That's an interesting one.
Yes.
I nearly slipped. That's a good one.
Okay. So this is the support they claim they give. I want Kuku to come in. Was it a needless fight between the Attorney General's Department and Martin Amidu in the course of the week?
No, it wasn't. See, I'm not sure what date. What is the date on that?
The statement of case that was filed.
Date.
26 February 2013.
Interesting.
That is his case.
No, wait.
At that time, they were not.
Hold on, gentlemen.
No, it doesn't matter. The institution.
No, he was not.
First of all, I
institution.
consider this an exercise in self-indictment of that office, that whole office, based on the sequence of events. But you see, what that statement that was issued, very disingenuous. It sought to take glory where it didn't deserve. And I think we should be very clear about it. It was provocative. Martin had been quiet. He was forced into the open by that kind of disingenuous, poorly crafted statement. That sought to give the impression as if they had even researched and provided him with those findings. Now, you go into Martin's affidavit in support of application for prescription of practice and procedural directions. And I'll read some portions. It says, on 22nd June 2012, I issued a writ and a statement of case in this action against the defendants herein. The first, that's the Attorney General. Second, Waterville. Fourth, defendants, that's Woyomi, were served with the writ and statement of plaintiff's case on 28th June 2012, 16th July 2012, and 10th July 2012, respectively, as evidenced by the photocopy of the results of applications for search annexed here with a marked exhibit MAASI. Listen. The period within which the first, second, and fourth defendants were to file their defense has long passed without any of them filing a statement of defendant's case as required by the Supreme Court rules. The results of a search conducted by me on 12th October showing that none of the first, second, and fourth defendants has filed a defense to this action is annexed herewith. Then he goes on to say this, and this is very important as far as my uneducated legal position is. He says, in view of the fact that the first defendant, second defendant, and fourth defendant have each been served with a writ and statement of case in this action, and have failed or refused to file their defense within the time limited for same, the plaintiff seeks practice and procedural directions from this court as to how the case should proceed to trial in default of defense. It is my belief that the first defendant, the second defendant, and the fourth defendant are deliberately delaying the hearing of this case within this session of the court or have no defense whatsoever to the writ and statement of the plaintiff's case. They came in February 2013. All this time, Martin had done all his things, his processes, his defense, the paid his fees, everything had been done. His claim. Yes, thanks for that. I don't know these things. Thanks for that. But he had finished all those things. It is my submission that this paper here they had no other alternative but to put up that case. So if that was the sequence, there was no need for the statement issued by the Deputy Attorney General. Absolutely. It was needless. It was provocative. It was disingenuous. And there's no need for us even to elaborate on the matter.
I see.
If you look at the sequence.
Okay.
But finally, and I want education, and it's relative to the whole Supreme Court ruling. Mr. Daisy made a point about the Shanghai group did not go to Parliament. If you go into the Hansard of 27 July 2006, when the government sent a loan agreement, the credit facility agreement between the Republic of Ghana and Barclays Bank, Ghana Limited, for an amount of $50 million for the construction of Tamale and Sekendi Sports Stadia to Parliament. That issue of the contract, the procurement contract between the government and Shanghai came up in the course of this debate. It was the argument of the minority then that that contract should accompany the credit facility. There were those of the opinion that since it was government that was funding directly the project and that there was nothing like a loan agreement, the loan agreement was separate from the agreement. So government didn't think it was necessary to bring the procurement contract to Parliament. There was a debate over that extensively. Then both sides came to the conclusion that they should find a cure to that lacuna and that the agreement should be shown to the minority side. If you read this Hansard, that was done. But the agreement itself was not debated on the floor of the House. Meanwhile, the Shanghai thing was sole sourcing by the public procurement law.
That's right.
The question I want to ask, and I want education, what is the effect of the Supreme Court ruling in terms of 1815 on even the Procurement Act, the law, where the space is given for some sole sourcing or even some procurement relative to the law, procurement law, even if it is an international business? Because there are different levels of tendering.
Yeah.
I don't know.
Once it is an international agreement,
yes.
Without a loan element.
No.
I'm just seeking information
agreement.
education. Government is doing the funding. It is not for a project. The agreement that you come and construct, should that also go to Parliament based on the Supreme Court?
Once you agree to grant or to sign or enter into that contract, which is international, then you have to go.
So it's just education.
International transaction or economic business.
It's because of transparency's sake, so that people will not sit somewhere in their rooms and just agree on these matters.
Then there's the need for some re-engineering of even the procurement law.
Yes.
That's the point I'm making.
There doesn't seem to be any contradiction.
No. The procurement law doesn't say that you can't go to Parliament. What if it's sole sourcing?
Under Section 41B of Act 663, the Shanghai contract was procured. Is it illegal? Is it invalid in the face of the Supreme Court ruling?
It sounds like one step that requires another step.
It will have a difficulty there.
Yeah, but that's the point I'm asking.
So,
let's hear the need for an additional element in the procurement law.
All right.
That's the point I'm making.
Not necessarily.
I'm happy we have arrived here now, because this is a point I was making. I'm saying that, you see, when you start the problem from finding out culprits, I
wanted your specific comment on what Kuku just mentioned.
Sir, I'll come there in a moment. I'm saying that when you start your questioning from the point of who has done the wrong, then you have a problem. Look, if there's any establishment or individual who or which has pulled us back as well make my law progress, I will put the blame on Parliament, because this constitution has been in effect since 1992, and there's a specific obligation on Parliament to delineate what is international business transaction.
But while they have not done that, you as an officer, you are also required to submit the process before them. You don't submit it before them, and you want to blame them.
I'm saying I'm saying that it's unfortunate you refer to the what do you call it, the first defendants thing as disingenuous.
Okay.
I mean,
not the statement. I mean the statement they issue, not the statement of claim.
After that statement, I also disassociate. myself with the deputy. I think that it was unnecessary at the time. Martin was entitled to his glory, and really nobody should have, tried to put a spin on.
Okay.
But
we have to move on to some other matters.
I think he has raised an issue that the public need to know. You can procure goods, you can procure services, isn't it?
Yeah.
So, at the end of the day, do you enter into a contract with that individual? If it is an international contract, commercial contract, you say go to Parliament. So whatever the procurement
but you understand what he's saying, that when that process is finished, it is a procurement that has been completed.
So at the end, there is international agreement.
But can Parliament handle the thousands of cases that will come? Okay. That is what
So is it good news now then that they have set up an ad hoc committee to begin to look into bringing up the legislation or fine-tuning that particular
I would say
portion of the
20 years late, and it has caused so much confusion and so much loss to the state. We shouldn't start. If there are specific criminal fraudulent acts, we must go after those persons.
All right.
But otherwise, if you say fraud, there are two types of fraud. I mean, the criminal fraud, and then in law we have what we call fraud, civil fraud.
So create, loot, and share. That's crazy.
Different from create, loot, and share.
Loves that phrase,
that's criminal.
Create, loot, and share. He said it's as if a brigade had been set up.
Exactly. We need to put this old article in proper context. Yeah. You see, after various coups, then we have committees of inquiries. Then we have commissions of inquiries. Yeah. Then we complain that monies were taken. Monies had not been properly accounted for. People should be debarred from holding public office for 10 years, for this, for that. So in this constitution, we said before you go for money, you go for a loan, send it to Parliament. Yeah. Let the people's representative know what is happening. So I do not think anybody is asking too much if we said every international agreement must go to Parliament. Without that, how do we know our foreign debt?
I've got some of your text messages here.
So I think
Ata Imoro sends this one from Wellens. He says, it is not how many pink sheets. Okay, sorry, but I should have seen that before. We'll read that when we do that subject. This one's from Bafo Agbogba. He says, give Matanamidu his full salary and benefits as AG and pay all expenses he has made while in court. Kofi Edupoku Kumasi writes, we do not have many Matanamidus in Ghana. Not even, okay, the person you are mentioning, I will not help you to advertise. Dan Kumasi says, if President Mahama is not part of the create, loot and share cabal per the Supreme Court, he should appoint Martin Amidu as the Attorney General. That argument too has been out there. Kwame Boachi Kumasi writes, this is a clear create, loot and share, and yet you say Ghana is poor. Congratulations to Martin Amidu. Kokobaku, you see how you have poisoned the people who are sending the text messages with your promotion of the create, loot and share. Okay, Paul Edu. Paul Edu Kisi right from Kwehu Tafo. I am very proud of Martin Amidu. He is my role model now. For a moment, I thought there were no such good leaders in Ghana anymore. Gabi Sak, right from New York. Mr. Martin Amidu, the chief citizen vigilante is my man of the year and deserves the highest honor of the land. All Ghanaians should rally behind him to fight against rampant corruption and a just cause for our dear nation. God bless our homeland, Ghana. Zakaria Safiano writes, Samson, I think it will not be out of place for Martin Amidu to form a new party and call it Citizen Vigilante Party. But as for Dr. Ayene's press release trying to claim a share in Martin Amidu's victory was petty and disgraceful. We need to take governance more seriously and stop this kind of rampage propaganda. Okay, sounding like somebody I know. Yabua Francis writes, I back the idea that there should be thorough investigations of those who were involved in the payment of those judgment debts. And I'll read the last one from Kojo Mono Asamoah, he sends it from Kumasi. Mr. Madinamidu deserves all the praises being hurled at him. Imagine what this money can do for the citizens of Ghana. The people who facilitated this payment to Waterville must be brought to face the full rigors of the law. Thanks, Mr. Amidu. Ghana needs more of your kind. And the Supreme Court certainly did not mince words in that when they used the Latin phrase for him. Okay, thank you very much. And before we move to the next subject, today I didn't quote anything from Justice Doshi. The man who always has a concurrent opinion to read, no matter how voluminous the unanimous judgment is, even in the ruling on the naval ship, the Argentine naval ship, he still had a concurrent view to show. Now, I'll read just one portion of what I captured from him for you. Justice M. Doche on jurisdictional matters, this is what he said. He said, the brazen and bold attempts by the Leonard Trial High Court judge to usurp the powers of this court are not in tune with the jurisdictional limits of the High Court. He says, the trial court must therefore hasten slowly when issues of constitutional interpretation are raised before their court, and unless the constitutional provisions in issue have been overflogged by the Supreme Court, the necessary reference must be made to the Supreme Court for it to assume jurisdiction. So he's saying if the High Court had referred the matters to it earlier, we may not have had Isofoton going to get what it got.
But was it raised?
Was it raised
at the lower court?
I suppose it was raised, but it was raised, and the judge agreed with the defendants there that the parents, for as long as the parent agreement had come before Parliament, there was no need for the implementation contracts to also come before Parliament.
Oh, I wanted to find out whether it was there rather that they took the consent judgment.
Yes.
Because if you are doing consent judgment, then you may not go into the details.
All right.
In other words, you lower your guard, the both of you agree that we want this judgment, and then the judge gives his blessing.
All right. Okay. Now, I'm hoping we can move quickly with some of these issues in the next few minutes. Now, there's the RLG matter. The RLG has made a proposal. Okay, I understand that. We will shift that a little bit down. So let's do the questioning of the arsonists who have been arrested. The arsonists who have been arrested. I'm sure that you have followed the news also that government has announced that some people who are said to be behind the market fires have been arrested and will soon be dealt with. There were those who felt that that announcement by government was only to back its original suspicion and was unnecessary. But the Information and Media Relations Deputy Minister Muntala Muhammad came back, I think, on Thursday to say that it was true and was not a hoax. I'll start with you on that point, Abraham. And maybe let me read you this, that the presidency has dismissed claims by some members of the opposition New Patriotic Party that the arrest of some persons suspected to be behind a series of fire outbreaks at the market centers in this country is a hoax. According to Deputy Information Minister Ibrahim Murtala Muhammad, government will soon publish detailed information about the suspects as soon as the security agencies are through with their screening.
I have information that they are in the BNI custody. So when they say it's a hoax, is it that there is nobody who has been picked up? I differ from that.
Who identified this? Is it the American guys who are in to help?
No, it's a collaborative effort. And don't forget that before the Americans even came, the local security were already looking out to find out who were responsible for this. We've heard all kind of permutations. Some saying that rats in the market, some saying that because the market has been used as a place for dwelling, so people cook there. But I say that time immemorial, we've had rats in our market. It's not now that we now have the rats in the market. The markets were not burning that way. You see? Or we now have fire rats.
Yeah, fire
okay.
rats.
So much as we could agree with the fact that probably because of the congestion in the market, some of these things could happen. But if you have one incident, it could be an accident. If it is two, you could say it's a coincidence. But when it repeats and it is serial, you cannot but come to a conclusion that this is enemy action. And so the government was not wrong when it indicated that they will have to look out for arsonists. And they believe that the nature of these fires, and most of the time, do you notice that it is when the president leaves the country that this thing happen?
Interesting.
That kind of coincidence.
Interesting. Who are these arsonists?
Oh, names have not been revealed yet. And I think that at this point, no name should be revealed because they are now screening them. And if you know the way the police works, when they go on a swoop at 37,
they parade them before the TV cameras.
I'm saying that when they swoop, they don't give them names and say that this is this person. They have to screen them because don't forget that you may damage somebody's reputation for life if the screen doesn't point to him. So for now, let's leave it at that. Let's ensure that the due process goes on. I think that they cannot be held beyond a certain number of hours. We all know.
That's the next question. When were they arrested?
So
when were they arrested?
No,
at least we're told about this before Thursday, and then Thursday the confirmation also came to say it is not a hoax. So it's been over 48 hours, isn't it?
Well, I am not sure that yet because the Deputy Minister of Information indicated that they are mindful of the 48 hours and they are not likely to go beyond the 48 hours. Whatever it is, these people will have their day in court. Due process, they are allowed to, as it were, hire lawyers, take lawyers to, as it were, prosecute their case for them. I do not think that there will be a stifle of any legal representation. But as it is now, some arrests have been made. Screening is taking place.
Mr. Ikotu, do you agree with those who suggest that this is mysterious, so to speak?
I agree. I agree perfectly with the statement issued by the young patriots, if they are those who actually did a statement. You know, most of the time, as we rightly pointed out, these people are paraded on TV. We all see it. I say, look, we have gotten a few of them. But now we are being told stories, mysterious stories about some people who have been picked. Now we are talking about screening. So, I mean, how? You talk about screening, something which is based on investigation. Is not a case of just swooping, that some people are smoking weed in an area, so you go and do a swoop. But these ones, you said you have done painstaking investigation, including international investigators. They've come and you now have the evidence. You know these are the arsonists, and you are telling us you are now going to do screening. So who have you picked? You just decided to go suspect people and pick them and create the impression that indeed what you said had come to, the birds have come home to roost or what? I mean, it's mysterious. I do agree with them.
If one of these people consulted you, what would be your option?
Well, of course, first of all, we are looking at the 48 hours. If after 48 hours they don't take them to court, they have a right to go and seek their freedom.
Availability to pay fees.
No, but he does pro bono like you also do. You also do. Yes.
It's strange. It's a strange story.
You don't think it's a strange story, do you?
Well, really, I don't think that this is a real, apart from information, it's not a matter that we should be discussing for now.
The markets are being burnt, and we are being told the people who are burning them have been arrested.
No. I'm saying that. Just wait. I keep saying talking about premature things. We tend to jump to conclusions.
I don't think so. I respectfully disagree.
I'm coming.
With you,
well,
Senior.
yes, I love to disagree with you. This is a democratic society. I'm saying that in this society, we've had a string of fires. Nobody seems to have an answer. Thank God, the security agency, they've arrested some people suspected to have been behind it. Now, our constitution is absolutely clear, as my brother said. Within 24, 48 hours, the people must appear in court. What are we talking about? Today is Saturday. So we don't have more than tomorrow. And then we will know whether it is true or it's false, but we should allow the legal system to operate. That's all that I would say. We should allow our investigative system to also operate. We must also have faith in our system. We go to sleep and wake up without much let or whatnot in the society. You don't know the number of people, security personnel, who do not sleep, go around to make it happen. And then we wake up and say, the police are useless, they are collecting bribe, they are doing this. It's a lot of work. I say that when they say that they have arrested some people, we must start with a position of faith in them. Yes.
And that is where
Mr.
Ikotu is saying,
yes,
this is not a situation of a soup where you now need time to sift through who you have. This is arrest made upon painstaking investigations. So you are sure of the person you have arrested.
No.
Otherwise, you don't announce that you have arrested arsonists.
No. I mean, he has been an attorney general before, and he knows what it takes. There are some situations you don't want to disclose because of information. You lose the people. You lose track of information. So it is important. I'm saying now, 48 hours or 24 hours. You cannot be claiming that
it's paid upon yourself.
The deputy information and media relations minister said that the security agencies have also been able to prevent an attempt to burn another market in the country. This is serious.
Yes, I'm saying that is why we must take this matter serious. I'm just saying, look, I'm saying that if you have a string of fire outbreaks, as we've seen, it's something that you be careful about. And I told you that within the first 6 months, my own experience, within the first 6 months of coming into force of any government, a change of government, there are so many destabilizing factors. Some intentional, some unintentional, some as a result of the loose situation, like in this way, maybe the case handling and all these cases and all that. So many factors. And you have to be careful. And I'm saying we must thank God that we are together as a country. And the first thing is the government must give law and order, secure law and order. And we must have faith in those people. Monday will come, Tuesday will come. If they are fake, the courts will take over.
Why do you say that for evidence? Wrong? That is all there is to it. Produce the evidence.
All right, I want to take the Deputy Information Minister's clip briefly, and then we'll hear from Abdul Malik Wekubako Jr.
I want to state that some arrests have been made with regards to the fires that we have. We had a conversation with the security involved this morning, and they have confirmed to us that some people have been arrested. And again, the preliminary reports also indicates that, yes, some of the arrests, some of the fires may be, if you like, natural, and others were actually as a result of arsonist. And it also confirms the position and the statement His Excellency the President made. I did indicate after the statement that the President, indeed, per the position he has access to information that many of us in this country do not have, and it's important we look at it. A President will not come out and just make a statement without having a proper briefing. And it tells you that His Excellency the President made the statement when he responded to a question that yes, he wouldn't rule out an arsonist in regards to this fire. I think that this preliminary report has vindicated the statement His Excellency the President made in the position that yes, some are as a result of accidents, some by certain phases, and that is why I say that some people have been arrested with regards to the fires, and we're looking forward into arresting. In fact, they have been arrested not only in Accra, some have been arrested even in Kumasi and other parts of the country. In fact, attempts to engage in some, if you like, burn again, fortunately for us, have been foiled by the security agencies.
Thank you very much. This is Newsfile on Joy 99.7 FM. Abdul Malik, what do you say to that?
I remain cynical relative to this whole claim of arson being the cause of the market fires. I have said that the President, Ministers of State, and national security operators are not entitled to engage in speculation when it comes to these matters. They are required to give us a focused information and message. Arson. Not it could be or it could not be.
But there could be multiplicity of cases, and they are telling us that.
No. You put 25,000 Ghana cedis there to chase arsons. You are sure that we are looking for arsonists. Thank God, we are being told they have them. Look, within 48 hours, and I'm sure the time 48 hours is almost running out, we'll have to see the suspects in a court of law. Then we would begin to establish if there's any truth in this point. You see, it's so easy. I wouldn't have even rushed. I don't see why there was a rush to announce this. For me, it's marks of some, I have to choose my words carefully, but I like the Deputy Information Minister as a friend, and I don't want to hurt anybody's feelings, because this is a serious matter. The regularity of the fires was a basis for them claiming that it could be arson, the pattern. So these suspects, which markets are they linked to? Which of the fires?
Those details will come. They will come.
That is why there was no need for an announcement. Look, I'm telling you, there was no need for an announcement there. If they appeared in court, we will be told the particulars. Which markets were accidental and which was deliberate. You don't need to put yourself in this situation. I wonder, was it the security agencies that gave the clearance for that disclosure? What was the purpose of their disclosure? When you are not ready to give some further particulars. You don't give that kind of information out and decide that I'm holding on to some. You will actually provoke this kind of discussion and questions that we are asking. So you ought to be looking at it. Look, I can tell you honestly.
Let him finish.
What will happen in court of law will indicate the inadequacy, the insufficiency of whatever may have driven to the arrest of this so-called arsonist. The impression we get sometimes is that it was collaboration between the Americans and our security services. When? The Americans... when? How? Which market?
Does it matter? They are already in town and they have been to a number of markets.
I thought they were here, they were going to look... Look, I'm not sure they came in with the capacity to look for people who are committing those arsons, if indeed it is so. They were to investigate the fires, point to what may have caused it. In terms of the perpetrators, I'm not sure it's part of their brief. That would be an exclusively Ghanaian security-led thing.
They're supposed to give the scientific courses.
No, but that will not lead to the perpetrators directly. But we are giving the impression as if it was collaboration. That, for me, is a deficit. It tells me there's something wrong with the info that is being put out there. That's why I said I'm cynical. The packaging of that information, the timing of its release, all these things make me too cynical. And I just pray to God that we quickly move to the court. Because when it gets to the court, we'll see the identities, we'll hear some particulars, they will be linked to which fires, which markets, and then at least a certain picture will be created. The earlier, the better.
Right. If Koku is cynical about
your point briefly, we need to take a quick break and return to discuss the other issues.
Yeah. At times you don't know where you should stand, left or right. I mean, at the point in time, there's a complaint about not enough information. At another time, is that too late and information. When you come to you are running a government, or you are in government, and you come to a state of paralysis, literally, when people don't know where to turn to. Fires are just coming left, right, and whatnot. Or there's a state of emergency. The government must be seen doing something. And then in this particular case, where they say they have, security agencies have arrested some people, you don't wait until you've screened them fully. At least you should give people hope that something is happening. Right. And that is why you want to immediately come back.
Look, people, that was premature.
Well, I'm saying that the issue of it's one of measurement. Okay. How soon should you come, or how late should you come? Okay. I won't be surprised if Kweku later on Elon would have come to that. If you have this information, why didn't you bring
the dilemma of a ghost?
There's no evidence. will not agree.
Gentlemen, we'll take a break at this point. Let me just read these few messages, just three of them. Yao in Tema writes, I take the arrest of the suspected arsonist with a pinch of salt. I will not be surprised if the suspects turn out to be political opponents of the government. Bonti Benjamin writes, the Honorable Murtala Muhammad jumped into a hasty conclusion as though he was the investigator and the judge dealing with the arsonist. We must move away from such an act as a nation and rather find solutions to our many problems. Ghana deserves better, if not the best. And a final one from Imoro. He says, it is good to hear that some alleged arsonists have been arrested. It is equally important to ensure that such persons are not used as sacrificial lambs to cover up government's inefficiencies. They must be given a sufficient hearing. That is also a point certainly well noted. And the very final one, which sounds quite a bit some way, says something. I really want to thank the President for bringing the fire personnel from USA and their quick findings thereof. Can the President import American politicians to solve the gargantuan problems facing the nation? This one was sent from Don in the USA. Thank you. We'll be right back after this break. You're welcome back. This is Newsfile, your most authoritative news analysis show. The entire nation is glued to this this particular station at this time of the day. Now, we're talking about RLG, and they are in the news for all the good, bad reasons. They have given a gesture which was supposed to have been embraced, but it's beginning to bring some problems. They have written letters to all 275 MPs, members of parliament, and they are telling them to tell the RLG where they would want a borehole to be sunk in their constituency, and RLG will just go and do it for them, just like that. It will work like magic. But many are raising issues with it. They say this smacks of attempts to bribe the MPs. If you read the Friday, June 21 edition of the Sunday, June 23 edition of the Herald newspaper, the headline is MPs reject RLG's daylight bribery. And you have heard also the Ghana Integrity Initiative suggest that this is completely wrong. I would like to start on this issue with Nana Ato Dazi. There are some of the MPs who say, why not? Our people need boreholes. If someone wants to help us, we'll take it. All the things you're talking about, it will not compromise us. They'll go ahead. What's wrong with this?
Well, I think that it is unfortunate that two principles are clashing. Really, I mean, Parliament for itself should be taking some position. Good for our governance. A benefactor decides that we should have 275 boreholes. You can afford it. And it says, oh, MPs, just identify a place we can put it for. We can't fault that benefactor for that. I mean, I think it's a good a gesture. If all Ghanaians having enough money or companies would do this, that's good. The social, what do you call it, factor.
The issue is that the companies, Ghanaian companies, do this social responsibility thing, corporate responsibility job, but they don't need the MPs to do it. Just go
absolutely.
And do
Yeah,
it.
that's. I think I really, I don't know why they went through it. One thing I do know is that some MPs are taking objection to that. Why do you come through us? And more importantly, at this time, that's the point they're making. Why at this time? Because there are some related issues that Parliament is discussing. So the matter would appear to lend itself to some influences or likely influences. And that's what the Vital Azim and others say. I share a bit of that, you understand. Except that I did reading around, I did read a statement which was also made up by one, I think, parliamentarian, one of the chairmen, who says that this RLG thing apparently has been much earlier, before this parliament were convened. Just that it's been slowed down or they couldn't go through the processes. If that is true, then of course then it puts the matter in a totally different light. But otherwise, I think I also share the view that if Parliament, or rather Parliament must also have guidelines as to what they can receive, not as Parliament, but even as MPs in other jurisdictions. Just offering a certain.
What's your position? Is this inappropriate?
If the statement that the intervention had been there earlier than this Parliament or before this issue came up, then I will not fault them. I definitely will not fault them. But when you have a situation where they say, "Oh, every parliamentarian was given $5,000 or something like that," that is a specific allegation you can deal with. I'm not going there, but I'm just saying that in this RLG thing, I find it difficult to take a position unless I am given all the facts. One, that this matter did not predate this Guinea fowl, RLG, or the related matters. If it was there before them, then you can't fault them. It's just a sheer coincidence. But if it didn't exist, then of course people will be entitled to raise concerns. But I'm saying Parliament must have code of conduct. What parliamentarians can do, what cannot do. Every parliamentarian wants to get some job or some.
Do they need a code of conduct to hand them of potential conflict of interest situations?
Oh, absolutely.
They don't need a code of conduct to tell them.
No, what is conflict of interest? In fact, that is the problem. You see, because I've seen code of conduct for ministers and for various other persons. You must have this conflict
of interest. Has one.
Yes, conflict of interest itself. You must break it down. That's the point. You must break it. What is conflict of interest? What is it that a judge is seen? Is seen near the house of a petitioner, or for instance, what do you call it? I've had a situation near a plaintiff or a party. My client walks up to me and says, "Hey, what is happening? I saw we raised it in court." I just said, I was just passing through there. You understand? People are very, 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 very what do you call it, cautious.
As far as you're concerned, there's no potential conflict of interest situation in this.
I'm saying if their requests predate
problems that are being investigated.
Precisely. I wouldn't know that.
Abdul Malik, the MPs are saying, some of them at least, have gone on record to say it cannot compromise us. Give us the whole world. It will not compromise us. If matters concerning the company come before them, they will be upright.
Yes, I'm very intrigued. Surprised that we really can imagine a situation where this facility could compromise the corporate integrity of an institution like Parliament. I find it difficult to endorse that judgment. But whatever it is, let's look at the facts. In terms of the sequence of events, timelines, datelines, and the proposals that were put out there, this whole cry of foul or possible motive being malicious, an attempt to compromise the integrity of Parliament, is illogical and unsustainable. My facts indicate that on March 12, 2012, whilst celebrating the 10th anniversary of RLG, I think at the Accra Conference Center, International Conference Center, this initiative was announced. The RLG Foundation was formed then. I think it was then President Mahama, who was then the Vice President, who was on there. This was announced. There were members of Parliament there. It was on television, also screened live. And these two projects were announced. The RG for Water for Life, and the other one was Road Safety something. So it was open. On June 15th, 2012, the board of directors of the company met and approved the proposal. On July 24th, 2012, they wrote to Parliament on this project, asking for a list of beneficiaries and all this. At this time, note, there was nothing like guinea fowl controversy.
What is that?
There was nothing like that. And nobody protested. Then recently, May 16th, I suppose, 2013, they sent a follow-up letter. You know, parliaments have changed. I mean, there's a new parliament. And now many more constituencies. So obviously, you had to do some reinvention here and there. If you look at these timelines, and the fact that the initiative was also public, made public, transparency accompanied it, there were members of parliament present at the event, and then documentation trail, everything clear. I cannot understand why anybody would judge that this is an attempt to compromise the integrity of parliament. At that time, there was nothing like probing guinea fowl or anything. Mm-hmm. So really, if we want to be fair to the facts, we should look at the sequence and, judge the issue, rather than create the impression that this is a new initiative, it's been brought on board just because the company is seeking to compromise parliament. Even though I think that there's no basis for this judgment. But I found something, and maybe I talk too much, but I will say it, Okroma. See, I have cited, and this came through my parliamentary sources, a request from a very important committee of parliament to this same company, only about a week ago, asking for funding for sponsorship. And I'm talking of the Public Accounts Committee. This is even recent. Its members are going on a certain thing to do with auditing and things, I think, in Gambia. And they've requested for sponsorship. That's Public Accounts Committee. I don't see anything wrong with it. Indeed, it appears there's record to show that this company, alongside other companies, have been doing such sponsorships across the social and political divide. There's evidence. They've engaged in social corporate responsibilities across the place since they were formed in 2002. So I think that we talk too much, sometimes without reference to the facts. It's easy to throw out suspicions and use that to undermine the integrity of...
You're saying sometimes we talk too much, but you don't agree with Nana that it's curious depending on the timing.
No, but I've just established the timeline.
So that the Ghanaians who are talking about it have a legitimate reason
No, now we're giving
talk.
them the information. They didn't have the information.
Okay.
I expect members of parliament who want to talk about this to have the information, to do some due diligence before they go public.
Afenya Martin says he won't take it.
Fair deal.
It's just at most 8,000. He can afford to do one on his own.
They chose members of parliament because they are a focal point in their constituencies. The thing is not meant for MPs. It's meant for the communities. That's what it is. That's my understanding. It's not for MPs. And they decided they could have chosen the traditional authority. They could have chosen any district assemblies, all those, but they chose MPs. And it's focal. MPs change, don't forget. It's not an individual ownership. It's a community ownership. You see, sometimes when we open up and in a dispassionate manner look at some of these things, you take out the rough edges. If I can conclude.
Okay,
so for me, in the face, and I repeat, of the sequence of events and the timelines within the context of which the project was initiated, I think it's illogical and unsustainable to read into this any attempt to maliciously compromise the integrity.
Ebi, you don't agree with people who say there could be some ulterior motive behind it. Because why? You could have gone ahead to do it without reference to the MPs. And in any case, the more people within the community closest that you should be contacting should be the assembly members.
I am told, and I'm surprised whether Koku has that information and did not put it across, that it was at a workshop that the MPs expressed their difficulties. And I got this from a member of parliament who was on air. And indeed, this predates this guinea fowl thing. You get the point? In fact, as part of it was that they were going to give laptops to the members of parliament. And I'm told that they have discharged that responsibility. Question is, having discharged that responsibility of giving laptops, did that stop a member of parliament from raising an issue against RLG? Afanyo Markin, he has seen that something, in his view, has gone wrong. He has raised it. Why didn't that compromise his thoughts? So, for me, the attempt to want to scandalize, and we have done this over the years, Ghanaian companies have been scandalized to the extent that some have died in such a way that we cannot even trace their bodies again.
You're not saying the citizens should look on when wrongs are being done.
And that is the point. If wrongs are done, let the company, take the company through the due process. I have no difficulty if RLG is sued and they are allowed to go through the process if you think something has gone wrong. But don't scandalize the institution. Don't scandalize the company. In this matter, my understanding was that when the members of parliament indicated that they would want the boreholes, RLG decided that they should choose a location for that to happen. And so if today some members of parliament say they don't need it, I will urge RLG to go into the community and sink that borehole for the community. They should bypass those MPs and go and sink the borehole. That is because the essence of this borehole is to have the community members enjoy potable water. It is not for the MP. So for me, there is nothing wrong with the attempt by RLG to ensure that our people get potable water. It doesn't matter who they pass through. Once that borehole is sunk and the people can go there and fetch the water, that is what is important. I can understand the fears of people because it's coming just following the heels of the guinea fowl issue. But you need to situate the situation.
Which is being investigated by Shraj.
Good. So you need to situate the events. This is a promise made by the company long before this guinea fowl matter came up. It is now discharging its responsibility, redeeming its pledge. Are we about to say that in so doing, Parliament as an institution will be compromised? And I asked the question. There was an initial laptop promise which was done, and they discharged that responsibility. Did that stop Afanyo Markin, MP, did that stop him from raising issues when RLG was found by the whatever report that they were culpable in those things? I do not think so. I think that unless we are trying to downplay the intelligence of our members of parliament, if that's what you are saying, that they are not capable of deciphering what is right and what is wrong, then you can say that. But I think that members of parliament have the integrity, and what is wrong, and they will make a point out of it.
I'll take a quick one from you, and then I'll come to
records. And maybe there's a sidekick. Mr. Dyson made reference to the allegation of $5,000. Not for the records. It's very important. That's the allegation, yes, has long been discredited. And it was based on the fact that the person who peddled it was unable to authenticate it before the Vodafone Review Committee. This is in the findings of the committee. Okay. So for the purposes of this program, I think we should put on record. That was just a sidekick.
Mr. Eko, despite the information that is now supplied to inform the public that this was an enterprise began even before the matters that we are referring to came up, do the Ghanaian taxpayers, do they have the right, legitimate, to be suspicious?
I think we should situate this thing in the proper perspective. Are we talking about the conflict of interest situation?
The potential conflict of
Article
interest.
284 of the Constitution provides that the public officer shall not put himself in the position where his personal interest conflicts or is likely to conflict with the performance of the functions of his office. Now, it is true from the evidence given so far that this thing started long before the Gida and the Sada. But if they see a conflict of interest situation at this stage, are they not entitled to raise it? That you have been cited in Gida, you have been cited in Sada, and we are about to investigate that matter, or we are in fact investigating that matter. So to now take benefits from you might appear to us to be seeing ourselves in a conflict of interest situation. If we situate it that way,
it doesn't really matter that this is being done in the open?
No, because the point is, if I take something from you, then I believe that I'm being compromised in such a way that I'll now begin to treat you with kids' gloves, as it were. So, well, the whole parliament. Because a committee may have to work, at the end of the day, they bring it to the floor of the parliament itself, so to adopt whatever report they bring. At the end of the day, we are saying we want to do it for everybody. The option to me is that the water is not going to benefit the MPs. It's going to benefit the people on the ground. Yeah. So if they say they don't want it, why don't we just go there and give the water to the community? They need the water in any case. You're going to do this, and now you are even announced. So how is the MP going to use it for his, as a political, advantage? Well, how is he going to tell anybody I brought to borehole? Everybody knows it was RLG that did it. But if they could go and do their own thing privately and then bring the borehole and then use it, make political capital out of it, that I have given you water, vote for me again next time or something like that. But this is in the open. So if they say because of maybe, conflict of interest situation, they don't want it anymore, and if RLG, they have the money, they have the goodwill, and they want to do their corporate social responsibility, I think they should go ahead and do it.
Yes, this can be cured by full disclosure on the part of Parliament. Full disclosure can always cure conflict of interest situations.
That's where I mentioned the fact that it's being done in the open.
Yes, so Parliament can bring on board all the proposals and let the people scrutinize it. How much does it cost? All these things. If that is done, it cures this conflict of interest situation.
If I were advising RLG today, I would ask them to pull it back. You understand? I mean, they intended doing the right thing. They started long ago. Somehow there's some matters appear. They had continued with the process, and then the beneficiaries or those who are going through are raising a point of why push it. So just take it out, go to another channel, and then effect it or whatever.
And if the entities like public entities like Parliament goes to seek sponsorship too, they should not honor them. Is that it?
Absolutely. If these matters are happy, I'm saying that, you see, there are two things. One, the fact whether it was right or wrong for them to have, made the offer at the time. Now, from the evidence, it's quite clear that we are above board. But for now, the waters have been muddied a bit. And I think that it is in the interest of the corporate image itself to say, no, we never intend to, abuse them. We'll hold it back.
You are saying the water is muddied because there was lack of information. Now there is information.
I'm saying that when it comes to this, you must move one step higher. You see, it's a company. How much does this go? It's going to go to court, the RLG. Not so much.
Okay,
so,
let me hear Kweku. But before then, Kweku, there's a gentleman who is a tutor at the midwifery school in Nandom. He's called Akoleme Peter. He says, Samson, can you please tell RLG that we, the staff and students of Nandom Midwifery School in the Upper West region, need one of these boreholes badly, so they should come to our aid as well. We need them.
With or without, through their MP.
I am told that I'm reliably informed that they already have dug some boreholes in the Upper East region as part of their own initiative. This was a special initiative which is being trapped
under the Water for All project. Is that it?
Yes, under the same project. You see, but I find it difficult to accept that at this stage in our lives, we should allow suspicions and perceptions of some level to kill such initiatives. I'm being honest with you. Those no, relative to the fact that Parliament as an instrument is being used for something. Our members of Parliament is being used for something. You know, I don't accept that we should allow suspicions and unfounded, unsustainable perceptions to drive initiatives into the ground. I don't believe so. The members of Parliament who made those statements did not even know these facts. So clearly they were proceeding on basis of suspicions, because they are talking of the group wanting to undermine the integrity. That was the argument. That was the argument. We should stop these accusatory things. We don't have basis. I don't expect members of Parliament to run the show that way.
But who is not telling us there's no Gida and Sada?
There is. We've discussed them here. No. Can I? Yeah, but those. Well. No, I agree. But I'm saying that I'm even surprised if anybody thinks a whole Parliament can be compromised because of that. I can't believe that. Then they are not worth sitting in that house.
Oh, no. Westminster.
That's my view. No, I'm coming. That's my view.
Let's go there.
That's my view. I don't believe that our Parliament should be compromised because of this. But that's not the point. I'm saying that those MPs who made an issue publicly appeared not to even be well informed.
But you have agreed that Parliament's changed.
And that's unfair.
So, that's unfair. For example, is a new member of Parliament. No, but Katie Hammond was a member of the old man, so that doesn't count. Well, I was listening to
Parliament has an office. Parliament has an office. They have records. It's a house of records. So even if you are new and you want to make a case on such a thing, you can check.
So you are saying that
you don't proceed on the basis of no information or misinformation and attack the integrity or credibility of a corporate entity. You don't.
No,
because you are investigating that company when you haven't finished the investigations. What if the investigation proves that the company did nothing wrong? You would have destroyed the company.
Yes. So privilege. So when a contentious matter, I would have loved the member who started or those members complaining to have gone and tested it.
We can
destroy the integrity of that
can
company
preserve
as well.
some 2 minutes to talk about this other matter. Let me read this one too. This one says, we the viewers are not enjoying the program due to the interruption with Nana Ato. Okay, there's quite a lot of such messages. I didn't know that was what I was going to read. That's Gonja Najid. This one says,
what I'm saying is not pleasant to his ears.
Okay, Houghton Emmanuel is simply interpreting the Latin Dulce et decorum et pro patria moria that was given to Martin Amidu to mean it is sweet to die for one's country. Thank you. This one says, Edward Akapere says, Samson, if the construction of one borehole cost about 5,000 Ghana cedis, a modest quotation, 275 constituencies. Okay, so what are you saying? That the money is too much? RLG should not be able to afford it?
They are done in phases over to end about 2017 also.
Go and give it to the community and let's have our peace.
Okay, Godfred Ohene Mensah says, Samson, if the lawyers for Isofoton are being indicted, what of the judges who sat on the case and entered judgment in favor of Isofoton and Waterville? Judicial immunity. He's saying if they have been indicted. Well, in all two cases, Martin Amidu raised issues about the professional conduct of the lawyers involved, and the Supreme Court has referred those matters to the General Legal Counsel's Disciplinary Committee, and it says it is doing so for fair procedural reasons, so that they will avail themselves of that platform and sort the issues out there. Thank you very much, gentlemen. We have just about, I think, some 6 minutes to get out of here. I want you to, if you can, just in a minute, Abi, the petitioners have received, I suspect, they have received the report of KPMG, and they think there are discrepancies, there are issues that don't work well with regard to the pink sheet counts. They're saying, for example, that you find the count in Atugube's pink sheets. There are pink sheets in Atugube's, with Atugube's copies, which are not in the one that the registrar had. So there's some confusion.
There's no time. But you see, there was a meeting yesterday. Now, they raised these queries. They said that the respondents used some number of pink sheets to cross-examine Dr. Bawumia that were not found in the registrar's copy. They also said that there were some with Justice Atuguba, which was not found in the registrar's copy. So, if they add those ones to the registrar's copy, they will get their 11,000. Was that part of the court orders? No. The court simply said, count registrar's copy, do the entries. Count presiding officer's copy, do the entries. Now they are trying to vary the order of the Supreme Court. And that is where the difficulty is.
Are these not genuine concerns?
They are not, because there's a specific order. There's a specific order from the Supreme Court. Count the registrar's copies and do the necessary entries. They've done that. Count Justice Atugube's copies and do the necessary entries. They've done that.
Justice Atugube's copies, and they find that there are copies you have counted in Atugube's which are not in the registrar's copies which you counted.
Yes, but there's
and
an
vice
order.
Versa.
There's an order of the court. You are a lawyer. You cannot vary the terms unilaterally. You cannot vary the terms of this thing unilaterally. So these were their concerns. But you see, there's no time. They have realized that they have fallen short of the number of pink sheets they have filed. So try as they do.
If it is a result of the count, why should they not complain?
As a result of the count?
Mr. Ikotu. Yeah, if it's a result of the count.
The count was properly done. They agreed to that. But they are saying that pick here and put here. Put here and put here. That's what they are doing, which is not part of the order.
I think that the focus is on the paragraph 3 of the report. With respect, the letter. With respect, your letter is in clear breach of the agreement that the parties initialed with KPMG. In that agreement, it was provided that after the submission of the referee's draft report, the parties will present their comments on same, and thereafter a meeting will be held with the referee to discuss the draft report before the submission of the final report. I think that is what they are complaining.
That's the first part of their complaint.
Yes,
and Mr. Ikotu is reading a letter that was written by Akoto Ampao.
Exactly. That they are proceeding, or they have even filed. And they are saying that you are breached.
No. Yesterday the meeting was held. Yes. And KPMG are now to put the final copy on Sunday.
So they have now met.
They've met.
So
all of them have met.
Which means that the issues have now been raised. Whatever issues there are have been raised before KPMG. My position is that then they should take that on board as they go to court to present the final report.
In respect of the question of the laptops, that also came up. I'm being informed that Dan Boche has said that it is not true that they have received laptops from RLG. Now, this is where we bring the curtains down. Sorry, gentlemen, we are unable to continue. This show was brought to you by the kindest sponsorship of MTN Everywhere You Go, Bank of Africa, as strong as a group and close as a partner. And Lipton is also proud to be associated with Newsfile. Now, you can call Latida on 0204 336 444 for a high quality yet low-priced Africa wear, like I have. My guests have been Abdul Malik Kwekubako Jr., the editor-in-chief of the New Crusading Guide newspaper. Nana Atodazi is a former chief of staff and is a lawyer. Ni Ayikwe Otu is a lawyer. He is a former former attorney general. And Abraham Amaliba, he's also a lawyer, and he is with the NDC legal team. Samson Ladi Ayenine. Production for this show was led by Sedem Ofori. Good afternoon. The news is up next.
Close-up, deep action. We created it to give the world 3 times fresher breath and eliminate up to 99% of germs. Maybe we went too far. There's an outbreak of freshness. best ever from close-up. 3 times fresh.